In California, there are two types of custody. There's legal custody and there's physical custody. Legal custody is who's making the decisions regarding the health, education, and welfare of your children. Physical custody is more of what it sounds like. Who's got the children and when? And so that involves either joint physical custody, which is more of an equal timeshare. It's not necessarily 50-50, but it's considerable amount of time for both parents, or sole physical custody, which generally is a much shorter time period. I'd say less than 30% of the time. And under physical custody, really what you need is a parenting schedule so that you have a clear understanding of when dad's got the kids and when mom's got the kids. In California, there's a legal standard regarding custody called the best interest of the child. That is a big overall consideration of what the court always has to consider regarding what custody should be awarded regarding children. Best interest means what it sounds like. It is what is best for the children under the circumstances, looking at the totality of all the circumstances of the parent situation, the work schedules, what's going on in the family relationship. Is there a problem? Is there addiction? Is there other issues going on here? All these considerations have to be taken into account in order to come up with what is in the best interest of the children. In California, once you have custody orders in place, if you wish to modify them, generally what you have to do is file something called a request for order. And that is basically a motion where you are modifying the terms of what your custody orders are. But it's important to understand that you can have temporary orders, which are orders while your custody case is still pending. You don't have a formal judgment yet. And so in that circumstance, you can change the orders more easily than you can if it's where you're at the point where you already have a settlement or judgment in place. In that circumstance, you have to make a showing of a substantial change of circumstances, which is more difficult to show because you have to show that there's been a significant change from what the circumstances were before in order to get a change of custody. In a circumstance where a parent may want to move away from where the parties have been living, you have to file in California something called a request for order, but you're asking for a move away order. And there are specific laws and factors that the court has to consider in that circumstance. Oftentimes that's going to require an evidentiary hearing to make the court understand what is in the best interest of the child or children at that point. And it's factoring in how far the move away is, where the parties are, where the one parent is going to be moving to. Is there family that are in that area where the proposed move is? How bonded the children are with the other parent that's staying behind. There's a whole host of about 10 factors that the court has to go through and hear and address in order to determine, is it in the best interest of the children to be able to move away? And things like the distance is really one of the bigger ones. It's one thing to move an hour away or two from where you are currently living. It's another to move clear across the country. That's the changing of dynamics of the whole parental relationship. And that involves a lot more consideration of what is in the best interest of your children. If you have any further questions about custody, feel free to contact us at Maggio Law, Orange County Divorce Attorneys.